So I'm down to my last title upload for the Revised Penal Code Book 2 kasi I started uploading from Title 8 pababa and now it's the first half. So I'm down to my last one, which is Title 7, or Crimes Committed by Public Officers. It includes Articles 203 to 245. So it's quite long because there are a lot of articles to be discussed. But congrats that I already finished the whole book, and I really hope everyone who's also reviewing for their final exams like me passes criminal law too. So let's all pray and wish you luck and wish me luck as well. So let's start. Chapter 1. So preliminary provisions. Article 203 are public officers. So dinedefine muna yung public officers. So the requisites to be a public officer is that one must be taking part in the performance of public functions in the government, or one must be performing in the said government or any of its branches public duties as an employee, agent, or subordinate official of any rank or class. And number 2, that his authority to take part in the performance of public functions or to perform public duties must be directed by direct provision of the law, by popular election, or by appointment by competent authority. So, kailangan daw na-elect ka. So, ito yung mga nakikita natin yung mga public officers natin, like our mayors, our senators, the president, direct provision of law, yung iba naman ina-appoint, di ba? So, ito yung mga sinasabi natin public officer. So whenever a person applies to a public office, he has the so-called oath of office. If he is a high-ranking official, the oath is also before a high-rank official. So if he is a cabinet secretary, the oath is before the president or to the Supreme Court Chief Justice. So if he is only an ordinary employee, government employee, still he has an oath of office. Like me, I am a government employee. May pinirmahan ako and may ginawa akong oath of office when I took my position. It is a document which is entitled oath of office. So that person, that public employee or officer merely signs it. So Article 204 is knowingly rendering unjust judgment. So the elements of this crime is that 1, the offender here is a judge. Second, that he renders a judgment in a case submitted to him for decision. Third, that the judgment is unjust. Fourth, that the judge knows that his judgment is unjust. So ano ba yung unjust judgment? So unjust judgment is one which is contrary to law or one that is not supported by evidence or both. The source of unjust judgment can either be mere error or ill will. If the source of an unjust judgment is mere error on the part of the judge, then the said judge is not civilly, criminally, or administratively liable. So, kunwari, in a case submitted dun sa judge na yon for decision, the judge wrongfully interpreted a provision of law. So, ito kasi bago yung batas. There is no jurisprudence yet regarding that law. So the judge wrongfully interpreted it. So the judge cannot be held civilly, administratively, and more so criminally liable. The said judgment is an unjust judgment, parang rhyme, unjust judgment because it was based on this error in the interpretation of the law. However, there was no intent on the part of the said judge, considering the basis of the unjust judgment is a mere error. The said judge acted in good faith. But however, the unjust judgment is based siya sa bad faith. That is based sa ill motive sa part ng judge. Dito naman, pwede na siya maging criminally, civilly, and administratively liable. For him to be criminally liable, knowing that he rendered an unjust judgment, it is necessary that the unjust judgment is rendered out of ill motive or bad faith, out of greed, revenge, envy, or any other ill motive. So, he is known to have rendered an unjudged judgment. Pag based on mere error, again, walang criminal, civil, or administrative liability. So, we go now to Article 205, or judgment rendered through negligence. So, this is again committed by a judge who, in a case submitted to him for decision, renders manifestly unjust judgment. So, ito yung mga elements niya. Offender is a judge, he renders unjust judgment. So, it's due to his inexcusable negligence or ignorance. So manifestly unjust judgment means that it is evident that the judgment is unjust. A first-year law student would know that it is unjust, therefore it is manifestly unjust judgment. because he acted in inexcusable negligence or ignorance. So we go to Article 206. So unjust interlocutory order. So the elements here is that the offender is a judge, that he performs any of the following acts: knowingly renders unjust interlocutory order or decree, renders a manifestly unjust interlocutory order or decree through inexcusable negligence or ignorance. Next is Article 207, or malicious delay in the administration of justice. Number one, again, judge pa rin yung offender dito. Second is that there is a proceeding in court. Third is that he delays the administration of justice. Fourth is that the delay is malicious. That is, delay is caused by the judge with deliberate intent to inflict damage on either party in the case. So, mabilis lang yun yung discussion kahit marami yung articles. Anyway, so Article 208 is prosecution of offenses, negligence, and tolerance. So the acts punishable here is number one, by maliciously refraining from instituting prosecution against violators of the law. So note that in the first crime, he knows that the crime was committed, but he does not prosecute the offender. Then, second is by maliciously tolerating the commission of offenses. So in the second act, a crime was about to be committed. He tolerates its commission. It must be done with malice. Absent malice, Article 208 will not apply. So, ano yung elements ng dereliction of duty in the prosecution of offenses? Number one is that the offender is a public officer or officer of the law who has a duty to cause the prosecution of or to prosecute offenses. Number two, that there is a dereliction of the duties of his office, that is, knowing the commission of the crime, he does not cause the prosecution of the criminal, or knowing that the crime is about to be committed, he tolerates its commission. Third is that the offender acts with malice and deliberate intent to favor the violator of the law. So this is otherwise known as dereliction. So it can be committed by a public officer or an officer of the law who has the duty to cause the prosecution or to prosecute the offenders. The said public officer commits dereliction of duty in the prosecution of offenses, dun na nga, by knowing the commission of the crime, he does not cause the prosecution of the criminal. Again. So, ano naman yung pag-charged ka with the prosecution of the offenders? Fiscals, prosecutors, state prosecutors, those who can cause the prosecution of the offenders. Ito yung mga judge, barangay chairman, and persons in authority. So Article 209 is betrayal of trust by an attorney or solicitor and revelation of secrets. So the acts punished here as betrayal of trust by an attorney is that by causing damage to his client, either by any malicious breach of professional duty, by inexcusable negligence or ignorance. So there must be damage to his client, yung attorney, by revealing any of the secrets of his client learned by him in his professional capacity. Here, damage is not necessary. By undertaking the defense of the opposing party in the same case without the consent of his first client, after having undertaken the defense of the said first client, or after having received confidential information from said client. If the client consents to the attorneys taking the defense of the other party, there is no crime. So here naman, yung elements is causing damage to his client either by malicious breach or of professional duty, by inexcusable negligence or ignorance. Then yung second, yung revealing any of the secrets of his clients learned by him in his professional capacity. And the third one, yung undertaking the defense of the opposing party. We already explained this. Under Article 209, this betrayal of trust is in addition to a proper administrative case which may be filed against an attorney or solicitor. So aside from the criminal case in violation of 200 or of Article 209, he can also be charged in a case for disbarment, for violation of the lawyer's oath. We learned this in our legal ethics class. So, ito yung ibang mga charge na pwedeng ipataw din sa kanya. And these two cases can be proceeded at the same time. It does not refer to future crimes that are still about to be committed. When a lawyer takes his oath of office, he says or he promises, he swears that he shall be liable not only to the client, but also to the state, to the government. It is his duty to the government, to the state, of any future crime that is about to be committed more than his duty to his client. Hence, to a future crime, for the protection of the state and the citizenry, it is incumbent upon him to divulge, disclose, or to reveal the said secrets. So we go now to Section 2, which is bribery. So this includes Articles 210, 211, and 212. So ito bribery down. Article 210 is direct bribery. The acts punishable here is number 1, by agreeing to perform or by performing in consideration of any offer, promise, gift, or present, any act constituting a crime in connection with the performance of his official duties. So yung offender dito is a public officer within the scope of Article 203. So he accepts an offer or a promise or receives a gift or present by himself or through another. That such offender or that such offender, sorry, that such offer or promise be accepted or received by the public officer with a view of committing some crime, and that the act which the offender agrees to perform or which he executes be connected with the performance of his official duties. So yung second act na punish under direct bribery is by accepting a gift in consideration of the execution of an act which does not constitute a crime in connection with the performance of his official duty. So kung yung first one, it will constitute a crime, dito naman, binabribe pa rin siya, pero it will not constitute a crime. So here, yung offender pa rin dito is yung public officer pa rin. And he accepts an offer, a promise, receives a gift, or present through himself or by another, that such an offer or promise be accepted or received by the public officer in consideration of the execution of an act which does not constitute a crime, but the act must be unjust. So that the act which the offender agrees to perform or which he executes be connected with the performance of his official duties. And lastly, the third punishable act under direct bribery is by agreeing to refrain or by refraining from doing something which it is his official duty to do in consideration of gift or promise. So here, syempre, public officer pa rin yung offender. Then the offender accepts an offer or a promise or receives a gift or present by himself or through another, that such offer or promise be accepted or received by the public officer to refrain from doing something which it is his official duty to do. So that the act which the offender agrees to perform or which he executes be connected with the performance of his official duties. So, yung mere agreement ba, will it suffice? The answer is yes. Likewise, in the third act, by agreeing to refrain or by refraining from doing an act which is his official duty to do, in consideration of a gift, a promise, or a reward. So, if the thing that a public officer is required to do is to refrain from doing an act which is his official duty to do, a mere agreement to refrain to do an act will already give rise to the crime of direct bribery. It is not necessary to refrain from doing an act. It is not necessary to still receive the said gift. However, if the thing that the public officer is required to do does not constitute a crime under the second act, mere agreement will not suffice. So there must be actual acceptance of the thing. There must be acceptance of the gift in consideration of the execution of an act which does not constitute a crime in connection with the performance of his official duty. So bakit daw? Because the thing that he is being required to do is not a criminal act. It is his official thing to do, but he doesn't want to do it without the bribe first to be given to him. So it is only upon the acceptance of the bribe that the crime of direct bribery will arise. So whatever may be the act constituting direct bribery, in order to amount to direct bribery, it must always be in connection with the performance of his official duty. If it is not in connection with his official duty, it could be any other crime like estafa or swindling, but not direct bribery. So we have an example. So what if A wanted her daughter, si B, to work in Japan? So B was still a minor that time. She was 17 years old. So what A did was to ask the civil registrar to alter the birth date or the date in the certificate of live birth with the promise that that the first 2 months of the salary of B will be given to the civil registrar. The civil registrar altered the date in the birth certificate. So what crimes are committed by A and the civil registrar? So the answer here is that the civil registrar is liable for direct bribery because he agreed to perform an act constituting a crime in consideration of a promise that the 2-month salary of B will be given to him. The said act is in connection with the performance of his official duty. Therefore, he is liable for direct bribery. So he actually performed yung act. He actually committed a crime. Therefore, he is liable. He is also liable for falsification of a public document because he actually altered the birth date, which is a very important date in the birth certificate. So he is also liable for falsification of a public document. Without the said bribe, the mother would not have committed the said falsification. So are you going to complex them? Because direct bribery is a necessary means to commit falsification. The mother is liable under Article 212, which we will discuss in a bit. So yung indirect bribery naman. So the elements of this crime is that the offender is still a public officer, that he accepts gifts, that the gifts are offered to him by reason of his office. So indirect bribery is committed if the public officer accepts any gift or present by reason of his office that he owns. In case of indirect bribery, the public officer is not deemed required to do a thing. By the mere acceptance, indirect bribery is consummated. No acceptance, no crime is committed. So okay, I'll show you an example. So si A is the newly appointed secretary of let's say ano bang mga department, DPWH. So on his first day of office, si B visited si A. So sabi nagpay ng courtesy call tong si B. So si B naman, president siya ng let's say isang construction company. So they exchanged some pleasantries. So after when the president of the said construction company left, he placed a small box on the table. When he left, the new DPWH secretary opened the box and it was a key to a part, let's say parang Ferrari car in front of the building. So the DPWH secretary used it and drove the car. So dito ba anong crimes committed by the DPWH secretary? So he is already liable for indirect bribery. The president of the construction company does not require him to do anything. It was merely given to him because he was newly appointed as DPWH secretary. His acceptance brings about consummated indirect bribery. Therefore, indirect bribery has no attempted or frustrated stage because outside acceptance, no crime is committed. And this crime can also be qualified if the offender is a public officer entrusted with law enforcement. So another is that the offender refrains from arresting or prosecuting an offender who has committed a crime punishable by reclusion perpetual to death, and that the offender refrains from arresting or prosecuting the offender in consideration of any promised gift or present. Qualified bribery is committed by any public officer who is in charge with the enforcement of the law. So in order to amount to qualified bribery, it is necessary that the offender whom the public officer does not want to prosecute must have committed a crime punishable by reclusion perpetual to death. So we go now to corruption of public officials. So the elements of this crime is that the offender, so private person naman siya, private or public, makes offers or promises or gives or presents to a public officer. Second is that the offer or promises are made or the gifts or presents given to a public officer under circumstances that will make the public officer liable for direct bribery or indirect bribery. So ito yung kunwari kanina, 'di ba? Liable sila for bribery kasi tinanggap nila. Kasi there was an agreement, ganyan. Pero sa Article 212, yung pinapunish naman dito, yung taong ng bribe. So we go to Article 213, frauds against the public treasury and similar offenses. Article 213 punishes two acts. The first is fraud against public treasury. The second is illegal exactions. So what are the elements of fraud against public treasury? So that the offender is a public officer, that he should have taken advantage of his office, that he intervened with the transaction of his official capacity, that he entered into agreement with any interested party or speculator or made use of any other scheme with regard to furnishing supplies, making contracts, adjustment or settlement of accounts relating to public property or funds, that the accused had intent to defraud the government. So here, the public officer took advantage of his official position by entering into a contract which involves the furnishing of supplies or which involves public funds or property at the intention to defraud the government. So we go now to the second paragraph, yung elements niya. So here, the offender is a public officer entrusted with the collection of taxes, licenses, fees, and other imposts. So he is guilty of any of the following acts or omissions: demanding, directly or indirectly, the payment of sums different from or larger than those authorized by law, or failing voluntarily to issue a receipt as provided by law for any sum of money collected by him officially, or collecting or receiving directly or indirectly by way of payment or otherwise things or objects of a nature different from that provided by law. Here, the offender is a collecting public officer. A public officer who has been entrusted with the duty to collect taxes, licenses, fees, or other imposts. Only this kind of public officer can commit the crime of illegal exaction. It involves violation of rules on collection. So now we go to Article 215 or prohibited transactions. So the elements of this crime is that the offender is an appointed public officer. He becomes interested directly or indirectly in any transaction of exchange or speculation. Third is that the transaction takes place within the territory subject to his jurisdiction. And fourth is that he becomes interested in the transaction during his incumbency. So Article 216 is the oh, sorry. Ano to? 214. Oh, mali yung kanina. We already explained this. Ito yung kakasabi ko ng 215. So anyway, 216 is that is possession of prohibited interest by public officer. So the person's liable here is that the public officer who directly or indirectly became interested in any conduct or business in which it was his official duty to intervene. Experts, arbitrators, and private accountants who, in like manner, took part in any contract or transaction connected with the estate of the property, in the appraisal, distribution, or adjudication of which they acted, guardians and executors with respect to the property belonging to the wards of the estate. So our other Article 217 rather is malversation of public funds or property. So there is presumption of malversation. So what the elements of this crime is that the offender is a public officer or employee. He has the custody or control of funds or property by reason of the duties of his office. Those funds or property were public funds or property for which he was accountable. He appropriated, took, misappropriated, or consented or through abandonment for negligence permitted another person to take them. So, malversation of public funds and property can be committed either through a positive act, that is, that the said public officer is one who misappropriates, takes, or appropriates the public funds and property, or through a passive act, that is, through his abandonment or negligence, he permitted others to misappropriate the same. Malversation can be committed either through a positive act, which is through deliberate intent, or through dolo. He is the one who appropriates or misappropriates, who took the said public funds or property. So passive act naman is which is through his abandonment or negligence or culpa. He allowed others to appropriate or misappropriate the said public funds or property. We now go to Article 218 or failure of accountable officer to render accounts. So the elements here is that the offender is a public officer, whether in the service or separated therefrom. He must be an accountable officer for public funds or property. He is required by law or regulation to render accounts to the Commission on Audit or to a provincial auditor, and he fails to do so for a period of 2 months after such accounts should be rendered. Article 219 is failure of responsible public officer to render accounts before leaving the country. The elements here is that the offender is a public officer. He must be an accountable officer for public funds or property. He must have unlawfully left or be on the point of leaving the Philippines without securing from the Commission on Audit certificate showing that his accounts have been finally settled. Article 220 is illegal use of public funds or property. This is technical malversation. So the elements of the crime is that the offender is a public officer. There is a public fund or property under his administration. Such public fund or property has been appropriated by law or ordinance. He applies the same to a public use other than that for which such fund or property has been appreciated by law or an ordinance. So Article 221 is failure to make delivery of public funds or property. The elements here is that the public officer has government funds in his possession, that he is under obligation to make payments from such funds, that he fails to make payment maliciously. So the punishable acts here is that failing to make payment by a public officer who is under obligation to make such payment from government funds in his possession, refusing to make delivery by a public officer who has been ordered by competent authority to deliver any property in his custody or under his administration. Article 222 is offender officers included in preceding provisions, private individual who may be liable under 217 to 221. So private individual who in any capacity whatsoever have charge of national, provincial, or municipal funds, revenue, or property. Administrator, depository, of funds or property attached, seized, or deposited by public authority, even if such property belongs to a private individual. Those who acted in conspiracy and malversation, accomplice and accessories to malversation. So, can a private property be the subject of malversation? The answer is yes. Under the second act in Article 222, that is when a said funds or property has been attached, seized, or deposited by public authority, it now becomes in custodial legis, and it now assumes the character of being public funds or property. If any are misappropriated, then the crime committed is malversation and not theft. So Article 223 is conniving with or consenting to evasion elements. So, sorry, to evasion. The elements here is that the offender is a public officer. He has in his custody or charge a prisoner, either detention prisoner or prisoner by final judgment. That such prisoner escaped from his custody and that he was in connivance with the prisoner in the latter's escape or with his consent. So Article 224 is evasion through negligence. So the elements here is that the offender is a public officer. He is charged with the conveyance or custody of a prisoner, either detention prisoner or prisoner by final judgment, and such prisoner escapes through his negligence. So Article 225 is escape of prisoner under the custody of a person, not a public officer. So here the offender is a private individual. So conveyance or charge of custody of prisoner or person under arrest is confided to him. Prisoner or person under arrest escapes, and that the offender consents to the escape of the prisoner or person under arrest, or that the escape takes place through his negligence. Be it under 223, 224, 225, the offender infidelity in the custody of prisoners is one who has been entrusted with the custody and charge of the prisoner, whether the prisoner is a prisoner convicted by final judgment or by detention. He must be charged. He must be in the custody of the said prisoner, because the essence of the crime is the violation of the trust reposed on him. So, because the prisoners are accountabilities of the government, so can a private individual commit infidelity? Under Article 225, yes. If he is entrusted with the custody of this prisoner and the prisoner escapes either in connivance with him or through his negligence, then his liability is infidelity in the custody of prisoners. So, um, Article 226, 227, 228 are infidelity in the custody of documents. Article 226 is removal, concealment, or destruction of document. So the elements here is that the offender is a public officer. He removes, destroys, or conceals documents or papers. Said documents or papers should have been entrusted to such public officer by reason of his office. Damage, whether serious or not, to a third party or to the public interest should have been caused. And under Article 226, in order for infidelity in the custody of documents to arise, it is necessary that there be damage caused to a third person or to the public interest. Article 227 is officer breaking seal. So here the offender is a public officer. He is charged with the custody of papers or property. These papers or property are sealed by proper authority. He breaks the seals or permits them to be broken under Article 227. Officer breaking the seal, infidelity in the custody of prisoners to arise, even without damage caused to a third party or to public interest. Damage here is not an element. Mere breaking of the seal of the document will already consummate the crime. Then lastly, Article 228 is opening closed documents. Here, the offender is a public officer. Any closed papers, documents, or objects are entrusted to his custody. He opens or permits to be opened said closed papers, documents, or objects. He does not have the proper authority in fidelity in the custody of these documents. The public officer has been entrusted with papers, documents, or objects which may have been enclosed to a proper authority. So again, damage is not an element. Mere act of opening this closed document will give rise to the crime. So we go now to Article 229 to 230, which is the revelation of secrets. So revelation of secrets by an officer. So the punishable acts here is by revealing any secrets which affect public interest learned by him in his official capacity. Second is that it is necessary that there be damage caused, whether serious or not. Third is that wrongfully delivering papers or copies of papers of which he may have charged and which should not have been published, thereby causing damage, whether serious or not, to a third party or to public interest. So Article 230 Is public officer revealing secrets of private individual? Here, the offender is a public officer. He knows of the secrets of a private individual by reason of his office. He reveals such secrets without authority or justifiable reason. So here again, damage is not an element. Under Article 231, which is open disobedience, the elements are the offender is a judicial or executive officer. There is judgment, decision, or order of a superior authority. Such judgment, decision, or order was made within the scope of the jurisdiction of the superior authority and issued with all the legal formalities. Offender, without any legal justification, openly refuses to execute the said judgment, decision, or order, which he has a duty bound to obey. Open disobedience is committed by any judicial or executive officer who shall openly refuse without any legal motive to execute a judgment or decision rendered by a superior authority in the exercise of his duty and in the legal infirmities of the law. Article 232 is disobedience to order of a superior officer when said order was suspended by inferior officer. So the elements are provided on the screen. The offender is a public officer. An order is issued by his superior for execution. He has, for any reason, suspended the execution of such order. His superior disapproves the suspension of the execution of the order, and offender disobeys his superior despite the disapproval of the suspension. Then Article 233 is refusal of assistance. Here, the offender is a public officer. Competent authority demands from the offender that he lend his cooperation towards the administration of justice or by other public service. The offender fails to do so maliciously. So, public officer who shall fail to lend his cooperation towards the administration of justice or any other public service despite demand by the competent authority. So, ito naman, Article 234 is refusal to discharge elective office. So, ayaw mong umalis dun sa posisyon mo. So, the offender here is elected by popular election to a public office. He refuses to be sworn in or to discharge the duties of the said office. There is no legal motive for such refusal to be sworn in or to discharge the duties of the said office. So, Article 235 naman is maltreatment of prisoners. Ano yung elements nito? So, the offender here is public officer or employee that he has under his charge a prisoner or detention prisoner. He maltreats such prisoner by overdoing himself in the correction or handling of a prisoner or detention prisoner under his charge. So, Article 236 is anticipation of duties of a public office. And Article 237 is prolonging performance of duties and powers. So, ito na naman yung mga elements niya, which are flashed in the screen. 238 is abandonment of office or position elements. So here, that the offender is holding a public office, that he formally resigns from his office, but before the acceptance of his resignation, he abandons his office. So here, the public officer has already formally resigned. His resignation has not been accepted, yet he abandons to the detriment of public service. Ano yung penalty? In the abandonment of office, the penalty is qualified if the purpose of the said public officer is to evade the prosecution punishment of the crime involving violation of Title 1, Book 2, or crimes against national security. Article 239 is usurpation of legislative powers. Article 240 is usurpation of executive functions. And Article 241 is usurpation of judicial function. Ano ba yung usurpation? Yung tinatry mong kunin yung kapangyarihan nila. So, the elements are provided on the screen. My professor actually said that we should read this for our own consumption na lang. So, Article 242 is disobeying request of disqualification. Article 243 is orders or request by the executive officers to any judicial authority. And Article 244 is unlawful appointments. So, Article 245 speaks of abuses against chastity. The elements here is that the offender is a public officer, that he solicits or makes any indecent or immoral advances to a woman, that the offended party is a woman who is interested in making matters pending before the public officer for his decision, or where the public officer is required to submit a report or to consult with the superior officer. So, how are abuses against chastity committed? So, there are three acts. The first is that the public officer solicits or makes any indecent or immoral advances to a woman who is interested in matters pending before for his decision, or where the public officer is required to submit a report or to consult with the superior officer Number two, warden or other public officer directly charged with the care and custody of prisoners or persons under arrest, and he solicits or makes any indecent or immoral advances to a woman. And third is that the warden or other public officer directly charged with the care and custody of prisoners or persons under arrest, and said officer makes any indecent or immoral advances to the wife, daughter, sister, or any relative falling within the same degree of affinity by the male prisoner. So, ayan na nga. This ends our discussion. Sorry, medyo binilasan ko na. For Title 7. And finally, we're done with Criminal Law 2. Article 246 is already parricide. So, again, it's crimes against persons. Tips lang din na yung professor namin gave us pointers. So, I think kailangan talaga natin mag-focus dun sa mga crimes na talagang laging nababanggit. Although we have to really read everything kasi nga sabi ni Fiscal sa amin, connected talaga lahat ng crimes. It all, parang ito, it cancels out this, ano yung difference ng robbery to serious, robbery to serious illegal serious illegal detention, serious illegal detention, yung mga ganyan, yung mga complex crime, you have to remember all of those. So, I'm wishing you luck for your study in criminal law too kasi mabigat talaga na subject to. And I hope my video helped you in your review. Thank you!